Rappahannock County Board of Zoning Appeals to order. The first item is the roll call. Jennifer Matthews.
Here.
Alan Sharp, I'm here. David Connick. Here. Ron Rackland. Here. And Chris Bird. So everybody's here tonight.
And no one arrived late.
No one is
Bird is late,
but he was here before we started.
It's in the last August's meeting.
Okay. The first item on the agenda is the minutes from
What did we have to adopt the agenda?
August. Oh, I'm sorry, adopt the agenda.
I move we adopt the agenda.
Is there a second?
No, 'cause I think that the zoning administrator has an amendment to make to the minutes.
To the minutes?
Not to the minutes, but to the agenda.
The Board of Supervisors would like the BZA to appoint who they would like to serve on the planning commission, so you may want to add that to your agenda as an item.
I thought we did that in January. Don't we have the organizational meeting in January? Yeah. By our, whatever.
The board's gonna make that appointment at their January 7th, their organizational meeting.
Okay, now our procedure says we have an organizational meeting in January.
The first meeting of our meeting is in January. That's 20.
So I don't have. And nobody's thought about that.
We're not prepared to deal with that.
I'm not thinking about it.
Okay. Well,
Well, then can we put it on the agenda on the new business that we would consider the request of the Board of Supervisors, whether you accept it or reject it, that's fine, we can do it then.
what do we?
What's the big deal? What do you want to do?
Well, I would be inclined to just do it the way we always have done it, which is, because we do the chairman, vice chairman.
Uh-oh, the county administrator is shaking his head in a negatory way back there. But I don't know what.
No, but that has been we've had an organizational meeting in January, which is in our procedure.
May I address?
Yes.
Sure.
If the BZA would like to have representation on the planning commission at their January meeting, that appointment would need to be made in January by the Board of Supervisors. When we talked about this with the ordinance change some months ago, there was discussion that the BZA could contemplate and make a recommendation to the board at your December meeting so it would be ready for the Board of Supervisors at their January meeting.
Now,
I anticipate the board will be ready to make an appointment from the BZA to the planning commission and will benefit from a recommendation from your group.
Now, is it not true that the member who's there now continues until he's replaced? I think that's correct.
That's the way it's been.
But are you saying that they're going to do it whether we give them a recommendation or not?
Certainly, they're empowered to do it,
Okay.
and I think they would benefit from your input.
Well, why don't we
In the
just see,
future, we can,
why don't we just see what they do?
You know what they're
I
going
mean,
to do.
no, I don't.
You don't.
I'd be inclined not to do that since it wasn't on the agenda.
Well, another reason for doing it the way the chairman has suggested is that until we decide who are going to be the officers, like the chairman and vice chairman and all that, we haven't had, I don't ever think the chairman be also the representative and so forth. So anyway, that's, I don't care, do whatever you want.
Did you make that as a suggestion?
I made that suggestion that we discuss it under new business.
So that would be different from what was.
To just discuss if we want to make a recommendation or no.
You don't think we just discussed it?
Well, now we've already discussed it.
I was going to say this,
So let's go ahead and we had a motion and a second to adopt the agenda
as written.
as written. All in favor?
Aye.
Okay, the next item is the minutes from August 29th. And there were a couple of name changes or references that you needed to make.
Well, I mean, if nobody can remember who some of these people were, I listened to the video and
You
I just
couldn't know.
I couldn't catch what their names were. And I mean, it's not critical, I can just put, an unidentified person from blah, blah. I mean, there's just there's two blanks, I think, and three that I wasn't sure of. So I'll endeavor to find out who they were, listen to it again. I just thought maybe some of you might know. And Dr. Matthews has given me a couple of little changes, and we filled in the blank on page 2, so that's all fixed.
I'm
So-
thinking you could just put, it was mentioned that
Okay.
was someone.
Or another
yeah.
person, I'll
Yeah.
fix it.
Okay.
All right, so you want to approve them now, or you want to wait till I redo it?
I think we can approve them now with a couple, the 2 or 3
Okay.
typos, and then
The typos were something about cell phones, since not all cell phones have signal reception, instead of not all
They don't
cell
work.
phones don't work.
they do work, we just,
In other words,
So it's a double negative was removed.
and we're not going to go over here.
See?
but I think that's correct, it's very, not all cell phones don't work, some of them do.
So all,
Do you think I did that by accident?
you could say all cell phones don't work,
You could say that.
or some cell phones don't work. See?
All right, let's take a look.
Okay, so we're going to approve the minutes, subject to those changes, all in favor?
Aye.
Aye.
Yay,
Okay.
we're rolling now.
So we're unanimous twice now.
Next.
I'm assuming that's why a lot of people are here today. So the first one is Nationwide Pentecostal Evangelistic Association.
Mr. Chairman, I've recused myself from this because I have some connection to it, so I'm going to stand down
Okay.
while you all do that.
Okay, so this, and we're not getting into the facts of this appeal, but an issue was raised, and the question that we need to determine was whether it was submitted in a timely fashion. And Ron, did you have some thoughts on that?
Yeah, I went over the information, and basically based on 15.2-2231 of the state code, which is appeals to the board, it reads that, within that, it reads that the decision shall be final and unappealable if not appealed within 30 days. And a little bit farther down, it says the appeal period shall not commence until the statement is given and the zoning administrator's written order is sent by registered mail. So, based on the law as written and looking at the, basically the receipt for the certified mail and the date of the appeal, the zoning administrator's letter was mailed on the 22nd of November. And the appeal was received, on October. It was mailed on October 20th, and the appeal was received on the 26th of November.
You're saying the 22nd it was mailed?
It was mailed the 22nd of October, according to the receipts from the post office.
And the appeal was mailed on the 26th?
26th, it was received on the 26th. The 30 days ended, and the, basically the right to appeal, it was lost on 11/20/18. So therefore, they missed the date. And we can't, the decision of the zoning administrator is already final.
A question that I have was that in the notice of appeal that the zoning administrator sent it to the wrong person?
No,
So I don't,
No.
is that yes or no?
that's
Well,
no.
I actually think I read that. It's a letter 60 days prior to that.
Correct.
They're talking
The
about,
initial,
but that
the
wasn't-
initial
That was not this one.
contact was with the wrong person.
It doesn't appear. to be.
The initial contact was with the.
Right, but that was way back in July.
That was, okay, so I just wanted to make sure that everyone heard that and understood that, because it had been to a former president or something. Okay.
So based on that, I will make a motion that we do not accept the appeal,
That it wasn't filed.
because it was not filed according to 15.2-2331.
Is there a second?
I will second that.
I'll second that.
Okay, is there any further discussion? Okay, David Connick has recused himself. Is there all in favor of the motion to not accept, or to deem that this was filed too late? All in favor?
Aye.
Aye.
Opposed? Okay. The next item on the agenda is the Freitag and Hardy appeal of a Williams Tree Service related opinion. And the question here then is just setting a date for hearing unless there's a reason not to hear it. Mr. Connick, you're the clerk in this, or the secretary for this?
Right.
Is that right?
Yep. Well, before we do that, I sent a letter to you on the 15th because I was tied up earlier this week, and so I figured I better get it out sooner rather than later. The first issue that I think the board needs to resolve is whether you're going to follow the procedure that you followed in the past with respect to when an appeal is filed, not by the property owner of the subject parcel, but by an adjoining or adjacent landowner. And the last time, to my knowledge, this came up, a case that I'm pretty familiar with, was the Deacon's appeal in 2012, which I talked about in my letter. And in that case, the board, and three of you were on it, everybody but me and Mr. McEnroe were on the board at that time. You voted to have like a sort of a preliminary or a bifurcated hearing where first you had a hearing about whether or not they had standing. And second of all, and then after that, then you scheduled a full hearing on the actual appeal. So, I think the board should discuss that, and there's some case law on it. Mr. Hampshire wrote me a note, and I sent it around. I don't know if everybody got it, but I've got it here. It was at not till 4:45 this afternoon, that nobody would be here, and I told him that I didn't think the board would be deciding it tonight. They'd only be deciding, one, whether or not to get outside counsel to advise them if the board feels that's necessary, and two, when to schedule the hearing if they weren't going to get outside counsel. So that's the first issue. The second issue, I guess, has to do with the scope of what the hearing is going to be, but I think we ought to just defer that for a second until we get some clarity on what procedure you're going to do. If you're going to do the procedure you've done in the past and do it in a two-step way, or if you're going to do it all at one time. And I see that Mr. Reynolds is here, and I believe Mr. Reynolds represents the property owner.
I do.
Mr. Goff sent a note around today saying he was going to be representing the zoning administrator, but he's not here tonight that I see, so I don't know what position, if any, he's taking on it. Maybe not any at all. And I see the appellants are here, but their counsel said he couldn't be here. So anyway, I don't know if Mr. Reynolds wants to speak. I don't know if you want to let him speak to that, but I mean, he's here. So that's all I have, and I think we ought to resolve that question of how you're going to proceed first. I mean, I have to say, I think it's kind of somewhat of a thorny issue, and I think, I'm an attorney. I understand what the issues are, but I'm not the attorney for the board. So if you want to get independent counsel, you could maybe get Mr. Lockerbie or somebody like that. And I would think that Mr. Lockerbie could answer the question and look at the papers himself. I mean, at his office without having to come here, and he could write us a letter opinion, and if that's what the board wants to do.
So we have basically 90 days from
Right.
when they...
Well, that's what it says, but there's a Supreme Court case that says basically it can be waived, that it's directory, not mandatory.
Because
And also, Mr. Hampshire said in his note that he's reserving, I mean, I asked him, would they waive it? I mean, it's not really entirely up to them to waive it, it's up there, kind of, I don't know what Mr. Reynolds, if they have, Mr. Williams has a position on it, but we're not up against it yet.
It just started, right? I mean, the time just started.
Right, the time just started on just about a week ago. Well, not even a week ago, last Friday, the 90-day clock started running. So there's plenty of time to deal with this, I think even within the 90 days. But, so I think the first thing we ought to do is decide whether you want to have a hearing on standing, or whether you're satisfied you don't need to have a hearing on standing. Or what.
So the question, this letter was sent to Bob Mann, Benjamin residence?
You mean the original?
This letter that's the subject of the appeal?
Right.
Okay.
Well, it says Bob Mann, and then underneath it says Benvenue residence, and if you go back to
So the other,
Mr. Mann's original
Letter.
letter to Michelle asking for the determination, he's got a list of people that he,
And so who is actually bringing the appeal?
so there's 10 folks who are listed as the residents of the Rappahannock County, and he's representing, he's
Okay.
creating the letter with their,
So this is for both, really, right?
are you asking me my opinion?
Well,
Because
Okay, well, to me,
in my opinion, the answer to your question is no. He's not, because he can't. Because he can't act in a representative capacity because he's not an attorney, at least ways not to my knowledge.
but he
We went
was,
over that the last time.
he was a
Okay.
spokesperson.
He can't be a spokesperson, it's against the law.
so here is,
Only a lawyer who's licensed to practice law in the Commonwealth of Virginia, we went through that last time, is allowed to write letters to a tribunal or to an administrative agency
On
on
behalf
behalf
of
of
a
other people.
corporation.
No, or on behalf of other people. And to my knowledge, Mr. Mann is not an attorney that's licensed, not ways to my knowledge. And therefore, his letter is his letter. If all the other people had signed the letter, I think you'd have a different situation. But the only person who signed the letter was Mr. Mann himself.
so here's a question. The determination is not who signed the letter or who he was representing, it's who has an interest in the results of this letter, I would say.
Probably. I mean, that's
Which-
one way to look at it. I mean,
What?
we haven't faced that, and I'm not aware of any case law or any other decision where a determination letter was sent to a specific person, neighbor or property owner, and then someone else appealed it. The closest thing we've had is Harmony Manor, where the property owner asked for the determination, and, well, actually, they came to the BZA, they didn't go to the zoning administrator, so the BZA, and then the neighbors appealed. I haven't read any case where this exact situation exists, and that's why I suggest maybe you ought to get an outside counsel.
Do we?
Because the appeal is brought by someone who didn't sign the original letter. So I don't know if that matters or not. It may matter.
I personally don't think it matters.
Well, because I think that, I mean, basically we're looking at an appeal that is being brought to us by an adjacent property owner. And that is the issue we need to deal with right now.
Okay.
Who the letter was written to is not.
Okay.
Yeah, I would say
Michelle made her
I mean,
decision, but it affected all of the property owners.
So-
And even if they hadn't signed, I think they would still be within their rights to appeal the decision.
I mean, that doesn't mean we have an opinion one way or another
No,
about the appeal.
I'm.
No, it's just a question of does somebody who wasn't a party to it have the right to appeal it? And honestly, I'm not sure of the answer.
Okay, so I would say yes,
to,
that they do have the right.
Theoretically.
I'd say in this case, they do.
Well, then you've got the Friends issue of they have to say they're an adjacent landowner and they have to show that they're aggrieved. And, you know, there was the original filing and all it says is they're adjacent landowners. But under the Friends case, that's, in my opinion, that's not enough. You can't get standing just by saying you live next door. You have to show some harm.
Okay, so the question is, do we need a hearing on this? or-
Well, I know that's what the board
No,
did
I'm-
before.
I'm asking the question.
Right.
Do we need a hearing on this, or can we just decide that we will hear it tonight?
Well, we're not going to hear it.
No,
We're going to make a
decide if you will hear it.
That we- But I believe that we should have outside counsel. And maybe it can be done from afar, as Lockerbie lives elsewhere, but he's familiar with Rappahannock County.
Now, you're talking about just on the issue of whether the appellants have standing?
Yes.
Is that good? I mean, are you saying that we need an outside attorney in order to make a decision on whether we're going to accept the
Well-
appeal? Or whether
Well, I
we're
think
going to
once
want to
we
be
ex-
represented?
Once we
At the
accept,
hearing,
as
you
we
know.
accept the appeal, I think we're still going to need to have legal counsel.
That didn't really answer the question. Are you saying we need an opinion about whether to hear it or just an outside counsel to represent us?
Well, you can't have an outside counsel represent us
Well-
at the hearing because we're listening to it. We're hearing the
Well,
case. if
to
we're gonna hear it.
advise us. how
To
about-
advise us.
Well,
I mean, what are you saying?
To
Do we
advise us, if we accept the appeal, then the next step would be that he help us
Okay, so not.
sort through
okay.
some of the legal issues.
But the other alternative is to have a hearing, as Mr. Connick is suggesting, to determine if the appellants have standing. Is that what you're suggesting?
I don't say that I'm suggesting that. All I'm suggesting is that that's what the board did in the past. When you had somebody directly next door that owned adjoining property that could see it and hear
And that
it and
was
so
you.
forth.
That was you.
That was me.
Okay.
So that's why I remember it so well. That's what the board did, and you made me come back from fishing to do it too. So if that's what you did for me, and I lived directly next door and could see it from my house, out the window, then it seems to me that you ought to have the board ought to have a consistent policy.
But maybe we learned our lesson. And
Maybe you did. I would hope so. Because if that's what you're going to do, I'm going to vote against it.
Well, you're
I'll
going to
tell you
vote
that
against
right
it
now.
anyway.
I thought it was a mistake back then, and I still do.
So what do we want to, okay.
I was going to say, reading.
Oh, so what you suggested, you're going to vote against?
I didn't suggest it, I just suggested
Okay.
the board ought to talk about it, because that was your policy in
Why don't we just,
2002.
when are we going to hear this? I guess that's the question.
Well,
Was there-
okay.
What's the issue about next meeting? Art was not available?
No, ours not available in February, so if we would hear it at the next regular meeting, I think it's January.
Oh, in January, he'd be available.
3rd?
January 23rd.
Yeah, as far as I know, he just said February, he couldn't.
Do we want to hear it at the January meeting?
I don't see any reason not to.
Do we want to have a motion to that effect?
No, we're talking about hearing the appeal.
The appeal.
Yes, I'll second that motion.
So he made the motion, you seconded it. Is there any further discussion?
I just have a question, so any issues about standing are going to be resolved at that same hearing? Right?
Yes.
Okay. Well, I don't know, you made the motion.
I mean,
I think that's very reasonable.
I think we can
Okay, fine.
infer that we think they have.
Well,
standing.
whatever.
I think they have
Yeah.
standing.
I mean, I don't know what Mr. Reynolds is going to say about it at that point in time.
Okay,
And it depends on what the evidence shows, so,
okay.
but that's going to be,
Well-
that's going to be one of the issues at the hearing.
Okay, we can start out with that question if you want to bring it up. If-
Well, I'm not going to bring it up till
Or
January,
if someone
when the
wants to
council's
bring it
in.
Okay,
Okay, fine.
so we have a motion and there's a second and we've discussed it. All in favor?
Aye.
Aye.
All right, I'll advertise it. The next question about this is, what's going to be the scope of the hearing? And that's really the issue that I think, more so than standing, is really a complicated legal issue that I think we do need to have counsel on, or at least get an opinion letter, because the way I read this appeal, the appellants are in effect asking this board to overrule or override or somehow, I guess, revoke a special exception permit that was granted by the Board of Supervisors in 2007.
No, but we're to look at her decision,
Right?
saying that she went out there, she looked, she said, okay, the wood
Well-
piles are too close in this, and she told him to move it back, and so we have to find out if he did follow through with his notice of violation. And so our duty is to look at her decision and was it in accordance. That doesn't mean that we overturn the
Well,
board of
Well,
Well, wait a
supervisors.
minute, I agree with you 100%, but,
Y'all get that?
but that's not what's in the appeal, or that's partly what's in the
But the
appeal. What's in the
hasn't-
appeal is that what Michelle, the zoning administrator, did was improper
Okay.
because the permit itself either expired by its own terms or it was null and void to begin with because it allowed a use that's not in the zoning ordinance.
So why don't we'll determine that at the hearing? Because
Well,
I think,
I don't know that,
I would
the
just-
Board of Zoning Appeals has that authority.
I
to do
would
that.
state that I think that there is at least one, if not more, debatable questions in this appeal that we can talk about, and if we don't want to consider part of it, we don't have to consider it. And I think we can make that determination at the hearing,
Okay.
Right,
and I don't think we need to make that determination this evening.
no.
No, I'm not
But
suggesting we make it this evening,
Okay.
I was going to suggest that we limit the scope of the hearing to exactly what Dr. Matthews said, which is namely the findings or the determinations that the zoning administrator made. If there were 3 of them, are they right or are they wrong?
And so if she said that the use was vested, for example,
Right?
and we can determine if we agree with that, correct?
Right.
Okay.
Well, that's the one I'm not sure about, because I don't know that we are the ones to make that determination. That's a matter of law. And the board can't,
But she did make that opinion, I mean, she did render that opinion.
well, she said it was vested, and they're saying it's not a valid decision, or it's not a correct determination, because the original permit was invalid.
Right.
And on those grounds, I don't think this board has authority at any time to go back and cancel a special use permit, and especially doesn't have the right to do it 7 years after the fact.
But again.
Or excuse me, 11 years after the fact.
But again, we can make that determination at the hearing.
That's, I mean, I was gonna say,
Because otherwise
we're
we're
getting
here-
way up,
Ahead
we're
of ourselves.
ahead of ourselves in that we're not having the hearing right now, so.
All right,
Really,
I just want the board to be
setting-
aware of that stuff, because frankly, on that question, I think we ought to get outside counsel.
I
Okay, so
agree
here's
that we
a better
need
question.
outside counsel because we have, basically, we're gonna have 1, 2, if Mr. Goff is here, that would be 3 attorneys that are gonna be, speaking to us.
Who's the third one?
And, what?
Who's the third one?
Reynolds, Blankenship,
Reynolds?
Oh, right.
Goff, and so we need somebody too.
And so, yeah, absolutely,
Besides
because
you.
only one of us on this board is an attorney, the other 3 of us are not, and we need to have someone who can advise us.
Okay, so what do we want? Do we want to get an attorney to be here?
Yes.
Absolutely.
And to be giving us.
Just like everybody, all the other Board of Zoning Appeals around the state in a situation like this, the locality would have an attorney that is assigned to that board or
Water
whatever.
authority,
and they would be
this county
represented.
has an attorney. and
So
we
are
do-
you authorizing me to line up an attorney?
Yep.
Works for me.
Is that, you want to make that motion?
I'll make that motion.
Who are you
We have
gonna
an attorney
get?
represent
Like
us.
probably Mike Locke would be an attorney.
Well, I think we ought to say who's going to get it. That's who you're going to get it. I'll second
Well,
it.
what if he's not available?
We need we need an attorney here, if somebody's not available,
What
we gotta
about
find somebody
Mitchell?
else.
Bob Mitchell? Does he do this kind of thing?
Lockaby's pretty reasonable. I'd like,
I like him.
yeah.
He was
Well, if
that
you can't do it for some reason, you'll let us know.
helpful. Okay.
Okay, and then we'll go from
He might have good ideas of other.
there.
Yeah,
Okay.
if he's in that network.
Okay, so there was a motion authorizing me to line up Mike Lockaby to advise us at the hearing,
That's
Be here,
correct.
yeah.
to be here.
Line up an attorney, basically, that's gonna be your decision,
Is
and
there-
however it works out, we don't need to
Is there a
put a
second?
name on it, I don't
I
think.
already seconded.
Oh, you second. Okay, any further discussion? All in favor?
Aye.
Aye.
Okay, the last, is that it on this?
So then
think so.
we have to say the date.
We
Well,
did
it's the
that.
next regular
So
meeting.
it'll be the 23rd.
Is that the 21st?
So we'll have two appeals on the same,
7 o'clock. No.
No, we don't have the other one tonight.
well, not, that's right.
Okay, short-term memory, second thing to go.
What's the first? I forgot.
I'll tell you after the meeting.
Okay, the next item, and I don't know whether we're prepared for this, rules and procedures. Did you, Mr. Connick, since you have,
Well, the last time we had met in August, wasn't it? Yeah, in August. Probably 3 months without a new tourist home in the county. How's that? I must have peaked out. So, the last time we met, we had an issue that came up again tonight. Actually came up twice tonight. And that is, our rules don't say anything about this whole business of when somebody comes before the board and they're a legal entity, like a LLC or a partnership or a corporation, the fact that they have to be represented by counsel. And if they're not represented by counsel, nobody but counsel can file something on behalf of another person or another legal entity. And I think we ought to put something specific in our rules that says that. And I think that if you want to have last time in August, we had an appeal that was filed on behalf of a limited liability company by somebody who was not an attorney, and the board I don't know what the board did, but the board allowed him to go forward because he subsequently got an attorney who endorsed what had been done. And that was sort of in line with what the county attorney suggested, but I think we ought to formalize that and have a change in the rules that specifically says that if there's going to be a grace period or a cure period for when that happens. I mean, there's one that you dealt with tonight, and I'm not going to talk about it specifically, but it also had that issue, which you didn't have to get to because it wasn't filed on time, so it doesn't matter. But nevertheless, I think people ought to know that, and that ought to be right in the rules, and I worked with Michelle a little bit on the form, and so it's sort of on the form now. And maybe that's good enough.
I was going to say, basically, the rules are the state code. It's written in the state code, and I think what we need to do, which would make it easier on the folks that we deal with or whatever,
is to pull that out and put those statutes
in the letter
in
itself that is written, that right now there's the reference to the state appeal code.
you're talking about the
in the letter.
The
application.
zoning administrator's letter.
But it would be on the
Letter,
letter
right.
that, this.
That essentially
pull out-
Reference in there, but we also need to
Perfect code.
reference the fact that, and rather than, we can reference the code, but put it in plain English so that people can read it. Just like with the 30 days, I think
That cuts me out, right?
I think it would be best if the reference is made to the code, but at the same time that, and in writing these letters,
A description
that
is there.
basically you don't date the letter until you're going to take it to the post office and certify it. And within the letter, then you state that the appeal is going to have to be made by such and such a date. So when the person gets the letter, they know exactly, they don't have to go to the state code and then start counting and whatever. It says right in the letter that your appeal must be received by a certain date. Also, in regards to LLCs and whatever, that if in fact you are a corporation, an LLC or whatever, that your appeal must be written by an attorney.
Okay,
So,
well, those are all
so it takes the guesswork out of it for the people that receive it.
Those are good suggestions, only the zoning administrator doesn't report to us, she reports to Mr. Curry back there. So, if it's all right, let's hear if he's okay with that.
It's got to be user-friendly.
Thank you for the recommendation.
You okay with that?
Thank you for the recommendation. We'll take
Okay.
that into consideration.
Well, some language like, okay. The other thing that I wanted to bring up, which is the same thing that Mr. Mackler brought up, is there's 2 or 3 that I'm aware of, letters that went out, 3, that weren't actually sent on the date that's on the letter, and my understanding is because the letter had to go from the zoning office to the county administration office, where in one case it sat for like a week, before someone walked it over to the post office, and that's why there's a big discrepancy between the date on the letter and the date it actually was sent. And I can't imagine why you can't advance the zoning administrator like $10 for mail, and then she can sort of, do a receipt and a voucher, and, hopefully she won't go buy any fire trucks or, tanks or anything like that with the money.
That's a great suggestion.
Or, an armored personnel carrier, that might be more appropriate for the zoning administrator.
Or you could loan her $10.
Okay, I'll never.
Okay. So does that,
These are
I mean,
considerations.
was with Ron's suggestion?
I think it's suggestion very, very.
Well, if they'll implement it, I think that'll take care of the problem, and then we don't, but then my next question is, okay, if somebody doesn't follow that, somebody files it on their own without an attorney in violation of that, is the board going to stick to it? And say, sorry, this wasn't properly filed?
Absolutely. That's why you put it in the letter, but you put it in there in plain English, so it's very easily understood.
Frequently asked questions.
Okay, as long as that's what you're going to do, that's fine with me.
So Gary, what would you like, a letter from us or a suggestion? Or,
This is all in your minutes, I think that'll do.
okay, so that'll do, okay.
Presumably this will be in your minutes.
It will be now.
Okay. Okay. I think that may finish us up unless there's something else. Is there a motion to adjourn?
So moved.
Second?
I'll second it.
All in favor?
Aye.